Welcome to the Texas Conflict Coach radio program. If you've ever experienced or engaged in destructive or unresolved conflict, then you know it leads to broken relationships, distrust, and damaging results. Our program will help you manage and resolve conflict effectively with strategies, valuable resources, and support. Since 2009, our radio program hosted guest experts from around the globe sharing their perspectives, experiences, and expertise while giving you food for thought. If you can't listen live, then download and listen to any of our 300-plus podcasts in our library at texasconflictcoach.com. So sit back, relax, or join the conversation every Tuesday evening, or tweet us at TXConflictCoach.
Well, welcome. This is Zena Zuneta, your guest host for today, and our program today is on mediation and domestic abuse issues. Some believe victims of domestic abuse are not candidates for mediation, citing the abuse and the inability to participate in the process. This show will discuss mediation and the benefits and challenges for victims of domestic abuse and for mediators. Joining me is Christy Cumberlander Walker. Christy has over 15 years' experience in relationship mediation. She's a former coordinator of mediation programs at the Franklin County Domestic Relations and Juvenile Court in Columbus, Ohio, and assisted in the development of the screening process for relationship mediation. She has served on the Advisory Council of the Association for Conflict Resolution Family Section and currently serves as a board member for the organization. She is a co-chair for the annual conference, Making Peace Happen, New Normals, to be held in Minneapolis, Minnesota in October of 2013. Christy has provided training in the areas of screening, mediation termination, and is a trainer for the Supreme Court of Ohio domestic abuse issues for mediators and other professionals. She is also a staff member of the Neighborhood Justice Center in Las Vegas, Nevada. Welcome to the program, Christy.
Thank you for having me, Zena.
Oh, I'm just delighted. So let's start with having you talk a little bit about the situation in which you are the mediator and the parties have had domestic abuse in the past. Can you talk a little bit about that, about what your concerns are as a mediator and what you think the benefits could be?
Yes, certainly. As a mediator in these specific instances, my concern is that the participants have the ability to mediate without fear or without being coerced. I understand that certainly when there has been a history of abuse, that is not always the case. And by no means am I saying that every case of domestic abuse has the opportunity to mediate or should be mediated. However, I do find that in some cases, such as when the abuse has been in the past, so we're not talking about a recent situation where there was abuse or violence, when the situation has been, the domestic abuse has been in the past, and most importantly, if the victim wishes to participate in mediation, then there is a benefit for them to have that opportunity.
So you're really not completely crossing out the idea. You're saying sometimes it might be possible.
I'm saying sometimes it might be possible. I believe that there should be, in any situation and in all situations, there should be screening for domestic abuse and domestic violence, and that the mediator should either conduct that screening or be aware of what has happened, because they will then have a basis for structuring the mediation in a way that all parties can participate fully, or in determining when it might be necessary to conclude the mediation early.
So what are they screening for?
They would be screening for the parties' capacity and willingness to mediate. By that I mean, is the victim able to express what it is they would like to see happen? if because of the domestic abuse, and I'm going to use the term domestic abuse to include domestic violence, but if they feel as though they cannot talk, that they cannot speak and say what it is they would like as an outcome, then they may not be good candidates for mediation. As mediators, what our job is to help them to have that conversation. And if one of the parties cannot fully participate in the conversation because they fear retribution, then they may not be the best candidate for mediation.
So that's one of the things that you're screening for, is that fear.
For the fear, and also for how the mediation will be structured.
Can you say more about that?
Sometimes when parties have had a history of abuse, to have them mediate in the same room does not work well. Because they have that history together, they know what triggers that will set the abuser off. As the mediator, I may not know that. They may feel comfortable participating in a mediation if they're in separate rooms, or if they are participating by telephone, or if they have their advocate or their attorney at the mediation with them. Those are things that it's going to be helpful for me as the mediator to know, so that they can take part in the process if that's what they wish to do, and at the same time be able to fully participate.
Now, are you screening both parties?
Yes, we do screen both parties. And we have a 3-part screening process. And I understand not all mediators have that luxury to be able to do checks to see if there have been any arrests made, how recent those arrests were. But certainly, as mediators, we can ask parties to complete a short questionnaire, and we can have a face-to-face interview with each party and have that done separately so that we can get more information and to see if the parties that we potentially might have in front of us are good candidates for mediation. And sometimes they're not. And sometimes there are things that we may need to put in place, such as a staggered departure and arrival time for parties, keeping them separate if there is a protection order in place.
So that's great to be able to do that kind of screening. If a participant in mediation gets through the screening and they're sitting across from a person that they're afraid of, and they are concerned that they might not be able to fully participate, what should they do?
Well, and that's the beauty of having had the opportunity to speak with each party separately before the mediation, because you can have that conversation about signals that you can give between the mediator and the participant that says, hey, I really need to take a break now, without that person having to say it, but having the mediator take ownership of, we're now going to go into a caucus. Those are conversations that you can have during the screening so that in the mediation it does go smoothly, but if the victim or the survivor feels as though, I thought I could do this, I'm not really doing real well, but I don't want to be the one that says I need to take a break. The mediator can do that. There can be set times, such as after 15 minutes we're going to take a break, so that the mediator is already planning that as a part of the mediation process. So in 15 minutes, there's going to be a break, and there can be an assessment as to whether or not the parties wish to go forward or if it's not going to go forward.
So really that separate screening session is very, very important. It's really something that makes a big difference in the ability to respond to the concerns of that victim or survivor.
I think it's critical. I think a separate screening is critical because we know that there are a lot of things as mediators we don't know. We're involved with the couple for a short period of time, and it's a snapshot in time. So we don't know what happened before, and we certainly don't want to do anything during the mediation that would cause people to suffer after the mediation. So these are things, such a screening is something that we can do to help ensure that we can give the safest environment that we can as mediators so that parties can participate as fully as possible for as long as they can. It may be survivors can do 15-minute smaller increments of mediation as opposed to an hour or a 2-hour session.
Uh-huh.
And
so
those
really,
are things we can talk about.
Yeah, that's great.
Yes, it does give the mediator and the parties some flexibility, and it helps to normalize what it's going to happen. So the mediator can take ownership and say, here's what it is we're going to do. We're going to have short sessions of mediation. And certainly one of the other things that mediators can do is invite advocates or attorneys to participate with victims and also perpetrators.
Uh-huh. And it sounds like the participant, the victim or survivor, can also invite an advocate or an attorney to come with them, but that's also something that they can do themselves. Yeah.
Right.
That's great. Well, one of the things you mentioned, Christy, earlier is that if that victim wants to mediate, that you would be more likely to do it, even if there were other concerns that you had that might point towards not mediating. Can you talk a little bit about that?
If the survivor is adamant that they would like to mediate, as the mediator, I may be looking more closely for their behavior in the mediation. Are they talking? Are they speaking? Have they shut down? Have they stopped communicating? Are they giving in? Are they agreeing with everything that's been said but not putting forth any options of their own? And if I see that happening in a mediation, then my job as the mediator is to do a check-in, and I would do that separately since there has been that history of abuse, to check in and make sure that the victim is still actively participating, and that's what it is they want to do, not that there has been some secret signal that in some way threatens them.
So really what you're saying is that that mediation participant, that victim or survivor, is really in charge of how long they want to stay and whether they want to continue. So they might say to you, Christy, yes, I really want to mediate. But in the middle, you might have some concerns or they might have some concerns, and you still can stop the process and check in together.
Certainly, and I believe that in cases where there has been domestic abuse, we do have the responsibility to check in and make sure that our parties are still actively engaged.
And that sounds like that's one of the things that you worry about most,
That is one of the things that I worry about most, and that I also believe is something that participants need to know, that at any time they can stop a mediation. We don't force people to mediate, and we don't force people to come up with a resolution in mediation. And we don't want victims to be re-victimized by participating in our process.
Now, you said that you don't force people to mediate, but what if they've been ordered by the court to come to mediation?
Being ordered by the court to come to mediation, generally, judges and magistrates, especially the ones in Franklin County, are familiar with the process of mediation and with the screening process that's conducted in the mediation department, and have enough confidence in the department and in the judgment of the people that work there to know that if the case is not appropriate for mediation because one of the participants feels that they cannot, even in a separate room, even with added supports, that they cannot participate, they accept that it is not appropriate for mediation. Because we have a variety of ways that we can deliver mediation, oftentimes people will find that they can participate.
Uh-huh.
But there are times when it's not appropriate.
Separate rooms or the phone or whatever.
The separate rooms, having them participate by telephone, having that support person there with them, making sure that they come and leave separately, having one person stay and letting everyone know that this is what's going to happen so that it's not a surprise or it's not a shock, making that plan that when the mediation is over, the victim is to leave, making sure that they have the ability to leave because they've driven themselves or their ride is there to take them as soon as we're finished.
Uh-huh. Uh-huh. So a lot of pre-planning really goes into this.
Definitely there is a lot of pre-planning because the benefits for the participants in a mediation are great. They have the opportunity to talk about the detail and what it is they would like to see as opposed to having a third party who may not understand their history, give an order that has to be carried out. They have a more active role in what will happen. In relationship mediations, especially if there are children involved, one of them doesn't stop being the parent. The challenge becomes how can they co-parent when there has been that history.
Right. So what you're saying is that the benefit to mediation is that they can tailor an agreement that really fits their situation.
Certainly. They can talk about how it is the exchanges are going to be made and where it is the exchanges will be made so that the victim is not in contact with the perpetrator. They can talk about how they can each enjoy the activities of their children's lives, those extracurricular activities such as sports, plays that children might be in, even going to the school and finding out from the teacher information. How can they structure those activities so that parents get to be parents, but no one is re-victimized? So that's the minute detail that would go into a mediation when there has been a history of abuse,
which they would not be able to do if they weren't in mediation. So let me just say that you are listening to the Texas Conflict Coach Blog Talk radio program, and we are talking about mediation and domestic abuse issues with Christy Cumberlander Walker. So let's go on and talk about what would happen if they didn't mediate.
Well, if they didn't mediate, certainly there are other ways for the situation to be resolved. They have access to the court. The difference between having the access to the court and having the court make those decisions is we know that oftentimes perpetrators present much better than victims in a court and often have more financial resources than victims do. So mediation allows a more level playing field in terms of them having the opportunity to speak. If they go into a courtroom, then the judge is going to make the decision for them as to what will happen with their children or in the division of their assets if there are no children involved. The victim wouldn't have as much opportunity to speak because we know that in a courtroom you get to answer questions from your attorneys. You get to answer the question that the opposition's attorney has for you. But as far as to go into that detail, we don't see that as much in courtrooms as we do in mediation.
So they would still get an outcome, but it might not be to the level of detail or tailoring that they might like.
That's correct, Zena. And also, it may not really work for them. It may be a one-size-fits-all, and that just may not work because of the history of abuse.
So that's why, even though there are concerns that the courts and the mediators are still trying to see if there's a way to work around it so that these victims and survivors can mediate.
Yes, that's the goal. And certainly we don't want people to participate in mediation that feel as though they can't express what it is that's important to them. The reality is there will be an outcome. The question is who's going to make those decisions. It's either going to be the parents who have to live with those decisions, or it's going to be a judge who is paid to give decisions.
And are these mediations ever done actually in the courthouse itself?
In Franklin County, if there has been a history of abuse, then the mediations are done at the court. There are mediation rooms throughout the courthouse, and there's the metal detectors that parties have to go through in order to get into the courtroom. If it's needed, certainly there's security because we are located in the courthouse. And I would say for anyone who is thinking about participating in a mediation and has suffered abuse in the past, that they find out where their mediation would be conducted, that they would also connect with their mediator to express what it is their concerns are and have that conversation.
So that even if they aren't invited automatically to a separate session, to call up the mediator and just let them know what's going on.
Certainly, they can contact the mediator and express their concerns and discuss different ways that the mediation can happen or if it should happen. Mm-hmm. As I said before, if there's been recent abuse, then certainly we don't want to re-victimize anyone by having them come into a room or a situation where the perpetrator is there with them. But we do want participants to be proactive and to have that right and that ability to say, this is what I need, this is what my concern is. I encourage any participant in mediation to have a conversation with their mediator and express what their concerns might be.
Well, that's a good point. So it's not even just limited to situations of domestic abuse.
Not at all. We certainly, as mediators, want to deliver to our clients quality mediation services. And in order to do that, sometimes we have to have our clients let us know what their needs are. So if it's not offered, you as a participant can ask for it.
That's great. And, Christy, I just want to be really clear. It sounds as you're talking that when you say domestic abuse, you're not just talking about violence.
I'm not just talking about violence. It may be financial abuse. It may be isolation. It may be psychological abuse. In relationships, people have history, and they know things about each other. Those are things that sometimes can be twisted in order to subjugate the other party. So whatever it is that participants have a concern with, if it's actual physical violence, whatever it is, they can have that conversation with the mediator and let them know that it's a concern so that the mediator can structure the mediation accordingly.
Yeah, that's really important. If a listener is trying to find resources in their area, where would you suggest they look?
I would suggest they start with the Supreme Court and find out what mediation services are available in their area. They can go to ACR's website where there's a Find a Mediator tab that people can look up mediators. Call mediators and understand who it is you're going to be mediating with.
And how about advocates? If they're looking for advocates, where would they look for those?
They would look for the domestic abuse shelters. The prosecutor's office typically has a domestic violence advocate. Often those advocates have a great knowledge about the mediation process and have also attended mediations, so they would be able to help prepare them as far as what it is they can expect.
Wow, those are some great ideas for places to look. You're saying when they talk to a mediator or to an advocate that they should really be proactive about what they need to make sure that the process will work for them.
Because, as I said, mediators are there for a short period of time. They don't have a deep knowledge of your history, and mediation itself is future-focused. But if your history is such that it impacts your ability to fully take advantage of the process, as you share that with the mediator, the process can be structured so that everyone can benefit from having mediated.
Well, that's wonderful. Well, we're almost at the end of our time, but I'm wondering if there is a final message that you want to leave with our listeners.
Yes, as a matter of fact, there is. I just want them to know that mediation is an opportunity for them to have a conversation that's free from coercion, and it's an opportunity for parents to create a parenting arrangement and property division that's self-made for them, that they have the ability to have input into. And I also want them to know that if they are participating in mediation, that they have to be vocal and let their mediator know what their needs are.
Well, that is really helpful. For those of you out there, if you're trying to get hold of Christy, you can find her information on the webpage, or her email address is Christy with a Y, CHRISTY, at ChristyCumberlanderWalker.com. Well, Christy, thank you so much. This was a very informative half hour. Thank you.
Well, thank you very much for inviting me. It's been a pleasure, Zena.
Great. And take care, everyone, until next week.
Thank you for listening to the Texas Conflict Coach. We hope you've enjoyed the program. You can find over 300 podcasts archived to listen at your own convenience at TexasConflictCoach.com or download the podcast at iTunes or Stitcher Radio. To learn about upcoming radio programs and resources, sign up for our monthly e-newsletter.